Alrighty, so welcome to the consultation. My name is Christina Jimenez.
And I am Josh Floyd.
And every Friday at noon, our team comes together to discuss complex legal issues pertaining to family law and criminal defense. Mr. Floyd and I have been doing this for a very, very long time. And we have kind of used this platform as an opportunity to have discussions about legal issues. Sometimes we agree, most of the times we do not. And we kind of talk through fact patterns. It is so important that when you guys are listening to this, that you do not accept this or do not receive this as any sort of legal advice. And what you will notice as we're talking through these fact patterns is that depending on one little nuance in a particular case, that will change our opinion on what is going to happen to that particular individual. And so it is important that if ever you find yourself in this particular situation, that you go and you hire yourself a really good family law attorney and you listen to what that attorney tells you after you tell them what is going on in your life, okay? And so I do encourage everyone to please follow us on social media. We have an Instagram, we have Facebook, we have TikTok, we have LinkedIn, YouTube page, etc. Any sort of social media platform, you can go and look for us, and our boy Keon has made sure that we are there and we're active. And also we have a podcast, so please like and subscribe to that as well, because the goal is to kind of give as much information, as much knowledge as we possibly can, because these types of cases are very, very difficult to navigate. And so we just want to kind of share the little that we know to hopefully help some people out along the way. So with that being said, Mr. Floyd, you want to go with the first question? You're on mute, Mr. Floyd. I'm going to need you to get with it today. Thank you. Thank you.
I'm ready for this week to be over.
Agreed.
Okay, so what happens if you fall pregnant by another man while your divorce with the child is processing? She is seeing a guy since her and her husband legally separated. She thinks she is pregnant, but when she Googled her laws for Texas, it seems as her ex will need to be put as the father. So Google legal advice, not a very reliable source. But yeah, go ahead and talk to us about how you fall pregnant.
Okay, well,
wait, this goes back to Sarabia's question on how you have a baby. Did we ever answer that question?
Oh my gosh, Floyd. Oh my gosh. Okay, so if you fall pregnant by another man while you're divorced,
while you're in the middle of divorce with children, she gets pregnant, what happens?
So yeah, I know what you're thinking. Like, this is really freaking simple. Why are you taking so long to answer?
You're gonna take it all the way down. I don't know. Go ahead.
Don't look at me that way. Like, you looked at me like you were already like, gosh, I know what she's about to say.
Yeah, let's roll with it.
Okay, simple answer is that you can't get a divorce until you have the baby. In most courts, I've had it happen one time where the judge has allowed us to proceed. And then so this is the guy that got her pregnant. I guess it's asking the question.
No, because he says she is seeing a guy since her and her husband. This is just some dude, some person that's curious about this lady's situation.
Okay.
Maybe a friend.
Okay. So she thinks she's pregnant. Why am I struggling with this question?
Good question.
Okay. So the way that it works is it's because it's a very complex issue or response. So, okay.
Did you get James or something on here to answer this question?
Yeah, maybe. Okay, so when she can't get a divorce while she's pregnant, okay? And I would say 99.9% of the time, that's what a judge is going to say. They're going to wait until the baby is born. When the baby is born, then at that particular point, the real father, the biological father, can show up to the hospital and he can sign an acknowledgement of paternity, but the presumed father, which is her husband, is also going to have to sign that document claiming a denial of paternity, because technically you cannot file or sign an acknowledgement of paternity if the mother is married to someone else. It won't be valid unless the husband signs the denial at the same time. You're looking at me like I'm batshit crazy. You don't think that's right?
No, I think you're right.
Okay.
Just going, your camera was going. Mwah.
Oh, I saw you sitting. I'm
Yeah, I
sitting.
saw that.
Okay.
It just looks good.
So you can do that. Sign the acknowledgement at the hospital. Presumed father signs the same thing, which he may very well want to do because he's probably not going to want to be the legal father of this kiddo because it's not really his, right? And then you can proceed with the divorce after that goes through. If for whatever reason, presumed father doesn't want to sign anything, or maybe the bio father doesn't want to sign anything, then what you're going to have to do is you're going to have to file a petition to adjudicate parentage. You're going to have to request a genetic screen. And when the baby is born, either the court will say that bio dad is now going to be adjudicated the father and presumed father has no legal obligation, or, if for whatever reason presumed father, the husband is actually the father, then the kiddo will be incorporated in the divorce, and then he'll be responsible for everything associated with that kiddo. But yeah, that's it, right? Did I miss anything?
Well, I mean, you could also just do if you don't want bio dad involved or whatever and don't want to adjudicate parentage, you can just do the non-adjudication in a divorce proceeding. Find that do genetic testing, have the court find the presumed father is not the biological father of the child, do a non-adjudication for him, but you don't actually have to adjudicate bio dad.
True that.
But no, I think other than that, you covered it up. But until that's done, husband is father.
Yeah. And so dad's attorney, scratch that, husband's attorney can request a genetic test, right? If he doesn't think he's the father, mom can request a genetic test. Also, bio dad would have the potential to intervene in the divorce proceeding to say, hey, I'm the legal father of this kiddo and I want to be adjudicated as such. So any of them could potentially say, hold up, let's get this genetic test. Why are you looking up and away at me?
I'm thinking.
I know you're thinking. Why are you thinking?
Well,
so intervene.
Would he intervene or would he file his own petition? He would have to intervene because that child's now subject to that suit, and then when he's removed from the suit, then it would be a separate suit. Yeah.
Right.
Okay.
Yeah.
I was just thinking through it.
Okay. I know you have to try to keep up with me.
It's taking you 20 minutes to answer this question. I could have answered before I started law school.
Okay, go ahead and answer it. And you get 30 seconds. Answer.
Okay. You just answered it. Or you want me to tell you what my answer would have been?
In 30 seconds or less, Mr. Floyd.
Okay. Start the timer.
Go.
Okay. So you have to wait until the child is born before you
stop.
can.
I have a real timer here. Go.
All right. So you do have to wait until the child is born before you can get the divorce. You're also going to have to do genetic testing or in some way determine that the husband is not the father to decide whether that child needs to be incorporated into the divorce or the child will be removed from the divorce.
That was like a half-ass answer, but
okay. I had 30 seconds.
You basically, I gave you the answer and you got it 17 seconds because I told you what it was. So we'll do this again on another question. How about the next one?
Yeah, the next one is 4 paragraphs long. Yeah.
Okay. So next question. My girlfriend wants to keep me out of my child's life. What can I do legally? A few months ago, I broke up with my ex. We're not married. We just lived together. We had an argument before we broke up and found out she was pregnant. In the heat of argument, things escalated quickly. She took her stuff and left. The argument was about grocery shopping, ingredients, facepalm. She's really a dramatic person and would lash out and insult me constantly as well. But that's beside the point. Then why are we? Yeah. Okay. So
that's the point.
We texted for a few weeks and she left. And I was telling her that she needs to calm down and not be so impulsive. And also that I want to help her with the baby. Well, I just want to visit my child. After I told her that she blocked me, and before she did, she said I don't deserve to be a father and that I will never see my child and I will never find her. I've not heard from her since. I'm assuming she's living with her mother, but I'm not sure. All I want is to see my baby and be a dad. This whole situation has completely ruined my mind. I don't want to be in a relationship with her again. I just want to see my baby. What can I do legally in this situation?
So first, I'll start just with some general advice, right? So telling a woman to calm down has never in history actually worked. So that may have been one of the issues. However, yes. Why do you shake your head at me?
Just continue. And I have the timer on, by the way.
Do what?
I have the timer on. You have like 20 seconds left. That's what you get for smart ass. You've used up your time.
Yeah, so until the child is born, you can't do anything. After that, you would file a petition to adjudicate, do genetic test, find that you are the father, and then all of your rights and possession will be awarded in that order.
Hot docket, Floyd.
What?
Nothing.
Oh, you want me to go down unreimbursed health insurance claims and all that stuff?
I don't know. But I mean, it's the right answer.
It is the right answer.
It is the right answer. But I mean, you think that's enough? That's enough info?
No, it's not, because I think we need to talk about the shitty part of it. And so, although you can't do anything until the baby's born and you can prove that the baby's yours through genetic testing, she could come back and request medical expenses for the birth of the child that you didn't get to be involved in, which sucks.
Hold on. Have you ever had a judge do that? Award medical expenses?
Yeah.
Yeah.
Yeah. Now, not in this scenario where mom would not let him be involved, right?
Mm-hmm.
But I have had it done when dad just wasn't paying anything.
Okay. Interesting.
I mean, sure, if he hires us, we go argue like, look, I wanted to be there and you didn't, right?
Right.
And maybe we get away from it, but I think if I'm her attorney, I'm making the claim.
Okay.
So, and then once you get adjudicated the father, the next shitty part of it, depending on the court you're in, is because the baby's so young, as a father, you're incapable of caring for the child in court's eyes generally. So you'll get very limited, restricted visitation. But
God, let's not get Floyd started on this.
That's just the way it goes. But there are some courts that are up and coming that recognize that men can actually take care of children too. It's weird. I know.
They're up and coming. They're up and coming.
Yes.
Okay.
So you'll have to go through all that, and then she'll pull the whole breastfeeding card on you, which is kind of a trump card for kids that age. So you have to jump through a bunch of hoops to maintain that relationship, but if you want it, you'll get it.
Don't you think though, so you're trying to make it like this whole blanket like statement, like this always happens in every single case. It doesn't happen every single case where just because you have a brand new baby that dad is automatically going to get restricted visitation.
No, I said there was a few courts that don't see it that way, but let me ask you this. For every child under, let's say, 6 months of age, on a contested custody case, what percentage of dads won that? Yeah, no.
I know.
And what percentage of them received restricted visitation versus just a standard possession order?
So percentage that won, I would say maybe like, gosh, 2%. I'm gonna go 2%. And percentage that received unrestricted visitation, I'm gonna go maybe like 5.
Yeah. Society
I
sucks.
do think that it depends, and that we have had cases where dad does get standard visitation, he does get overnight, but say he does get custody. And really what the courts are going to be looking at is, are you an experienced dad? Right? I think that when you're a brand new dad, first kiddo, maybe you're younger, maybe you're living alone, you don't have a woman there in the home. I'm not saying that it's right. I'm just saying this is what the courts look at. All right. So
you're identifying the problems with the court system. Go.
Yeah, well, so that's what the judges are going to look at, right? So if you don't have experience, which again, it's crazy to me, because if the roles are reversed and it's a woman and she just had the baby, and as she's a young mother, her first kiddo, maybe she's living with her dad, the perspective is just different, and the same rules don't apply. It's not right. It's just the way that it freaking is, and it sucks. It does suck. But the way that if you are a father and you want to be an active participant in your kiddo's life, I think the things that will help you, and we're dealing with a brand new baby, under the age of 6 months to a year. If you have previous kiddos, showing that you were an active, participant in raising that child. I had a case where I was representing dad, and there was like a 5-year-old little boy. And then I want to say that the baby was like 9 months, and then they went through a divorce. And what is Daniel saying? We fell on top of another defense.
Yeah, because the question was if you fall pregnant.
Oh.
Right. And so Sarabia is explaining how you get pregnant again.
Oh, okay. Thank you, Daniel. That was a good one, actually. So
you've never heard that? Oh, we just fell on top of each other.
No. Yeah, I don't know that stuff. But anyway, so what I was saying is that if you're a father, I was explaining my case. So 5-year-old little boy, 9-month-old little boy, mom comes in and says, dad can't have standard visitation with the 9-month-old because he's still a baby. He's under the age of 3 and he can't be away from me. And so in that particular case, thank the Lord, my client had been very active in taking photos of the baby at night because the kiddo would sleep with him every other night. We had a recording where mom was basically bringing the baby in to dad saying like, hey, I can't handle him. He's throwing a fit. I need you to take care of him. We had lots of videos from the eldest child and photos of the eldest child where dad was taking care of that kiddo. And then obviously my guy didn't have any criminal history, drug history, like nothing crazy like that going on. And so in that particular case, we did get standard visitation with elections for that kiddo because I could prove that my guy knows how to take care of a kiddo just as much as mom, if not better than mom, and that mom was actually soliciting his help in raising this kiddo. And so, that's what you got to do. And it's not easy, but you can do it.
Yeah, and so, but that's just the general outlook of the public, and the courts have created this because that's the way that they rule, right? Is even the way that the way we're talking about it, right? Like winning standard possession for a dad for a child that's young is a win. That's not a freaking win, right? I mean, that should just be, right? I mean, like Sarabia said, he made a comment. Special schedule under 3 is crap, as CJ would say. It should be a consideration, not a presumption. I think so. The presumption under the family code is standard possession starts at 3, right? I think the courts went the wrong way with it, right? Like I understand the presumption, I'm good with that at 3, but under 3 shouldn't be less time. It should be more frequent time, right? So you take standard possession and you add an additional weekday, right?
But like what the thought process is behind that. And so I guess let's back up and let's talk about possession schedules for children under the age of 3. Okay.
I feel like we're about to run off all of my female clients.
If their children are under the age of 3, perhaps. If like most courts have a set schedule or like a set idea of what should happen for children at a certain age. And so most of them will say 0 to 1. This is the possession schedule 1 to 2. This is the possession schedule 2 to 3. This is the possession schedule. And as older they get, or the older they get, the more time that they're going to get. But typically when the kiddos are below 3, what most judges and most courts try to do is they try to do like on Tuesday, dad gets a couple hours, Thursday, dad gets a couple of hours, and every Saturday and Sunday, dad gets a couple of hours. Okay. And the idea, at least this is my understanding, is when the legislature was kind of coming up with this whole system, is they were talking to child psychologists and they're saying when kiddos are this little, going a whole week or a week and a half without seeing the father is actually going to be more harmful to the child than helpful, because they need to have that time to develop the bond, which is why it's supposed to be more frequent contact. Now, Floyd's issue is, why is it only a couple of hours? You can't do anything in a couple of hours. Why isn't it every other day, right? An overnight with mom and overnight with dad. Is that something that you would like to see, Mr. Floyd?
Yeah, so that's what I'm saying is like, yes, I agree with the studies that the more frequent contact for children that age is better, right? But instead of taking the standard possession order and reducing it, add to it, right? And
but you
add a couple days, huh?
You can't add to the standard possession order.
Well, not.
Well, because then potentially dad would be having more time than mom. And now mom is potentially going Thursday, Friday, Saturday, Sunday night without seeing the kiddo, which is now you're not thinking of moms. And what you're not doing is you're not thinking of the kiddo. That's why I'm saying, like, if it were going to be expanded,
Nobody said expanded.
If it were going to be modified, then what should happen is maybe like a 2-2-3. Or like a 1 night and a 1 night. Like it has to be something where kiddos going back and forth between the homes, but not a standard possession and then expand that. No, the frequency is what matters.
Right, but what my idea, what I was thinking was.
Nobody asked you. Do we have a way to limit commentary on Facebook Live?
So Sarabia is right on track, right? I mean, he always comes in with the most intelligent comments. He knows what he's talking about. Unfortunately, he doesn't always agree with you. And if he's always right.
Continue. What were you going to say? Go.
So what I was going to say is the standard possession order, first, third, and fifth weekends, Friday at 6 to Sunday at 6. Okay. And then Thursday, 6 to 8. No elections, right? And so then what you do is you say dad gets Tuesday, Thursday, and every other weekend. You've now increased the frequency of the visitation.
I literally just said that, Floyd. Literally was saying every other day they should have this visitation.
After telling me that you can't modify to add to the standard possession order. So all I did with standard possession order is added a Tuesday visit.
I don't like the whole weekends. And just like I don't like the whole weekends for mom and dad not having access to the babies during that time. It should be something like every couple of days or something. It's just, exactly. So
it's what keeps the sharps, Rabia.
It doesn't make sense. And listen, I was blessed to have my husband be an active participant with my kiddos when they were that age. Floyd, I've seen you firsthand with your kiddos and how you take like front seat on a lot of those things, even when they were freaking brand new, right? I believe 100%.
Newborns or brand new?
They were brand new. Like, were they not brand new? They're brand new. And so
I think they're about 9 months old.
So, but I've seen it, and I've seen like my uncles and my brother and my dad, like it can be done. And this presumption that dads can't do it, I agree with you. It's just, it's dumb. It's antiquated, and it does need to be changed. I just don't know that it will be.
It will be. It will be. We've got some judges coming up that are making the change.
The up and comers.
The up and comers, and so hopefully it catches on. But yeah, we're not going down that path. So yeah, it needs to be changed.
It does. But again, right now, most courts don't have that perception, and so there's things that you can do to try to show them that as a father for a baby this age, you are ready. Parenting classes, CPR classes, I don't know, having your mom or your aunt or somebody live with you. And I know it seems freaking nuts, but those are the things that we've used to try to get more visitation for babies that are brand new.
And you have to read that book. What's that book that everybody has to read or something whenever you have a baby?
What to expect when you're expecting?
Yep, that one. Yep.
And then there's also a what to expect the toddler years and the newborn years. Did you read all
I
that?
should have read that one.
Yeah. They need one for teenage years because I'm struggling.
Yeah, agreed.
So anyway.
And they need a what to expect when you're married after 5 years.
What's interesting, and I don't know that we've ever had this issue, but I'm just kind of thinking about it when you mentioned the doctor's appointments and like the birth of the baby. Like that sucks. Like, can you get an order to allow the dad to be present at those?
There's proof you're the dad. No judge can give you any rights to anything until you're the dad.
What if you are married?
So this is going to take us down a different road, but I think the problem is going to be, can you be the presumed father of a child that is not born? Is it a child? And
Yeah.
we don't go down that path.
Right. But don't you think it's kind of BS though? Like the first.
Absolutely shit. Yeah, it's terrible.
Now, I will say that we have had cases where like the mom and dad are separated and dad tries to go to the hospital and like mom's family removes them or they're kicked out of the hospital. And I will say that I've had some judges get royally pissed off at the mothers for doing that to the fathers. And so yeah, I understand if you guys just are not seeing eye to eye, but that is like a once in a lifetime event that they will never, ever get back. And it just, I think it's very, very offensive to a lot of courts. And so if you can maintain your composure, I mean, you should be focused on some other things and not him during that labor process. Let him be there. Just let him be there. You guys be cool for a little bit and then go on. And maybe it can't happen. Maybe things are too horrific between the parties. I don't know. But if there's any way possible, try to do it because it's just, I don't know. I've had judges get really pissed off about that stuff.
Yeah, and I've actually, I don't know how I feel about it. It's not what I expected, but I had requested that my client be allowed in the delivery room. And this judge didn't allow it because she didn't want mom stressed out during delivery because it may have an adverse effect on the baby. Right.
Right.
Now, my client's upset about it, but I've never seen that position taken. I can kind of maybe understand that. Right. Still, dad misses out on it. Right. But that's at least a decent reason as to why you wouldn't want him in there.
But that's why I say I think it depends on what has happened between those two parties, right? Like if there's a history of family violence, if he like cheated on her, if, you know, he was emotionally abusive towards her or vice versa, like if there's that type of stuff, I think that if you exclude him and then it goes before the judge is going to say, well, I understand. But if you guys are separated and you're still texting him on the back end and you guys have what is perceived to be an okay relationship, even though you're not together, and you just get pissed off on that particular day for whatever reason and you don't allow him in there, when the judges were upset, that was why they were upset, was because there was really no legitimate valid reason to exclude dad from that room. So just think about it. Something to consider.
Well, on a side note, since we're talking about this, same thing with like first Christmas, right? A lot of people get upset about that, which I don't really understand because I really think the first Christmas is the worst Christmas.
Okay.
They can't open presents. They can't do anything. They don't show excitement. You give them wrapping paper and they're happy, right? I mean, it doesn't really start getting fun until like 3 or 4.
That's true. That's true.
So don't worry about fighting over the first Christmas. Fight for the third.
Okay. That was really like not relevant at all. Can y'all hear my family screaming in the background?
You're who's screaming? Do we need to call cops?
My kiddos.
No, are they okay?
Yeah, they're just yelling at the dogs and each other, and my husband's yelling at them. And so my apologies in advance. School's out. So yeah, here we are. Okay, next question. I think we've exhausted this. You were way past your 30-second.
No, I answered the question. You expounded upon it, which took us down a bunch of roads.
Okay. Well, hold on real quick. This idea of blocking him, I don't deserve to be a father. I will never see my child. I will never find her. I haven't heard.
Call me, buddy. I would love to take this case.
So we need to talk about this from the perspective of mom. Moms, don't do that. Don't use your children as pawns to hurt dad because y'all's relationship has fallen apart. Not only is it not good for your kiddos, it's just being on the opposite end of that, like Floyd's saying, like call him, being on the receiving end of that as your attorney, it's tough because there's no legitimate basis for that. You can cut him off from a romantic perspective. I have nothing to say to you. You and I are done. You're POS, whatever. But you still got to let him know, here's, a picture of the sonogram, or went to the doctor, baby's doing good, baby's due on this date. Don't cut him out of that information, because I'm just telling you, when you show up to court, it's brutal. And if you're just giving him enough to know that everything's cool, then I think most judges are fine with it. They understand if you don't want to be, texting him and calling him and doing all this crap all the time. But this idea of you'll never find me, you'll never see your kid, you could lose custody because of that. Don't do it. Please, please, please. So now we can move on to the next question. Sorry.
Okay. Oh, good. It's my turn to read, right?
Mm-hmm.
Can I move out of state during a divorce retrial in Texas? Mine and my ex-husband's divorce was finalized this week. We have 2 kids. It was a default because the 2 lawyers I talked to told me that if I agreed with what was in the original papers, I didn't have to respond to them. So I didn't. My husband took his chance and changed everything in the papers. They also state I can't move out of state of Texas. I'm wanting to get married once the 30-day deadline is up, and the person I'm marrying lives in Louisiana. We are getting retrial done to try and change some of the things in the papers. Will I be able to move out of Texas during retrial since everything will be over the phone and Zoom during retrial? It does help to know that my ex has been living with his fiance for the past 7 months, even before the divorce was filed. He's in Washington State in the U.S. RMA. This is a fun one.
Yeah, there's a lot of
30 seconds, go.
can you move out of state during a divorce retrial in Texas? If dad is living in Washington State, depending on what your order says, potentially yes, you can. Should you? No.
How about we answer correctly this time in 30 seconds?
What do you mean that is correct?
Since the order in effect does not allow you to move outside of Texas, you cannot move outside of Texas.
But he's living in Washington State. So presumptively the order states that if he moves outside of that geographic area, she also can have the geographic restriction lifted. Therefore, she can relocate. That's why I said, depending on what your order says. Oh,
So
yeah.
you're adding facts to the order. Okay, got it. Okay.
You're adding facts. I'm going with the Texas Family Law Practice Manual.
This
Presumptively says,
doesn't say that it says I can move out if he lives out of state.
where does it says, will I be able to move out of Texas? He's living in Washington State. It doesn't say either way, Floyd. I'm going with the presumptions. I got it right.
Well, okay. So he's in the Army in Washington though, but is he domiciled in Washington or is he domiciled in Texas?
I don't know. You're adding facts.
Why? No, it says he's in Washington State in the Army.
Well, I don't know. I'm going to presume that he's domiciled in Washington. What are you going to presume?
I wasn't going to make a presumption at all. I was going to presume that the court order said exactly what she said. It said that she cannot move out of the state of Texas.
So geographic restrictions, the standard, like what is it called? The Family Law Practice Manual?
Mm-hmm.
Yeah. So Family Law Practice Manual is the language that is typically incorporated in orders. It's kind of like the default language. And the default language when it comes to geo restrictions is typically, hey, you're restricted to this particular area, but if the other side isn't living in that area at the time that you want to reside outside of that area, then you're free to move. It's basically lifted. Okay. And so what Floyd is talking about is if he is not actually, if he's just stationed in Washington, but that is not his permanent residence, and Texas is still the permanent residence, is the geographic restriction lifted? I'm going to say no, it's not lifted, right? But if his permanent residence is in Washington State, then I would say yes, the geographic restriction is lifted and she's free to move. But it depends on what the order says.
Well, so let's think about who drafted the order.
Correct.
So it probably doesn't say that.
Right.
So I was right. All right, move on.
Again, you're adding facts. We don't know. We don't know what it says. So,
well, we know Mom's attorney didn't draft the order because she didn't have one.
Well, and that's why my closing remark was you probably shouldn't, not while a motion for new trial is pending. Like, I feel like that would be a horrible idea.
Yeah, despite what the order says, I think it's a terrible idea.
Right. And then if a motion for new trial is pending, this whole idea of I want to get married once the 30-day deadline is up, you can't, because if the, oh Lord. Okay. So how it works is if a divorce is granted, that's your final order, right? But if there's any potential basis to set that order aside, you file a motion for new trial, you go in, you have a hearing, you explain to the court why that judgment should be set aside. Judge sets aside that judgment, and now you're still married. Everything goes away, you're still legally married, so you can't run off and get a divorce. Because if it's set aside, then your second marriage, or excuse me, you can't run off and get married. If you do, then your marriage would be void. Void.
I think so. Yes.
Yeah. So don't move to Louisiana, don't get married. And yeah, until you figure out what's going to happen on the motion for new trial.
Did you not find it the least bit humorous that she's calling him out for living with a fiance for 7 months, but she's ready to get married like 30 days right after the divorce?
I mean, but she's not living with him, so that's okay, right?
I guess, right? I don't know. I just thought that was kind of funny.
Yeah. So the other thing is on this question, this idea of trusting your soon-to-be ex-husband to do the right thing and not hiring a lawyer. What are your thoughts on that, Mr. Floyd?
So I think it's a terrible idea. I'll start with that. But he was kind of right? The law doesn't allow husband to request anything that's not in his pleadings, right? Which is probably their basis for the new trial. However, this is what happens when you do that. And now you've spent thousands and thousands and thousands of more dollars when all you needed was an answer.
And just to show up, like even if you didn't want to hire a lawyer, you could have at least showed up to that final hearing and said, Judge, this is, what he said that he wanted, or this is what we have agreed to, and then make sure that all of that got on the record, and then you would be fine. So, and we've said this like a million times before, if you're in a situation, you need to try to find an attorney, and there's different resources available. If you're struggling financially, you need to try to do that, because otherwise you end up in this situation. And what if, hypothetically speaking, her lawyer screws up the motion for new trial and doesn't plead it correctly because it's very, very technical, and then the motion for new trial gets denied, and now you've lost your kids potentially, or you're stuck in Texas potentially, because you didn't handle it correctly the first time. So
there's a lot of attorneys that mess up those new trials.
Yeah. I'm trying to think if there's anything else she could have done. The two lawyers I talked to told me that if I agreed what was in the papers, I didn't have to respond to them. I know.
Better lawyers?
Yeah. And I'll say, like, this idea of he took his chance and changed everything in the papers. We've had a motion for new trial, same exact scenario. There was something that was in the request in the original petition, and what they showed up to court and asked for was completely different. We were successful in getting a motion for new trial granted, but by that particular point, the child had already relocated to live with dad, because that's what the order said. And so it was a beating to try to get that kiddo back. And in that particular case, what the judge did is he set aside the previous order, but then he immediately rendered a temporary order stating that the kiddo was going to stay with dad until the final trial. And then at that point, we had lost leverage, and it was really, really hard on mom. And so don't do that. Find a lawyer, file an answer, show up to court, and that way you don't have to deal with all of this crap.
And I guess we're not going to talk about whether the judge in that case had the ability to do what he did.
What do you mean?
Well, there was no pleas on file or request for temporary orders, no notice of a temporary hearing.
Oh, yeah, we're going to talk about all that.
So we're not going to talk about all that?
Oh, there was no allegation of significant impairment, an affidavit attached on Ahmad. Yeah, we're not going to talk about that.
Okay, good. Yeah. Love it when judges follow the law. It's great.
Yeah. So, you win some, you lose some. So, all right, next question. My turn?
Yeah.
Oh, Lord. Okay.
Why is Sarabia writing into us?
Uh-oh. What is he saying?
The question. Oh, the question.
Oh. Sorry, I'm slow today, Lord. Okay, I have 10 kids by 8 women. That's so rude. So rude. I have 10 kids by
Of
8
the women.
If all put me on child support, do I still have to pay for all? And how would I survive? Well, I started a job that's in another city here in Texas and travel back and forth to see and spend my time with them. But their situations are changing that I have to find a way to see my children due to their significant others becoming an issue. Wondering, is child support good? But in my shoes, would I be able to support myself? Okay, so I've started a job, I gotta travel, visitation's now an issue. Do I still have to pay child support for all these kids?
Yeah, you gotta pay child support. I was trying to look at the table to see what the percentage would be. It only goes to 7. So, but let's just say that it's 7. If you have 7 total kids and one before the court, it's at 13%, right? So it goes down, looks like, I don't know, about 0.3 from like 5, 6, 7. But let's just say it's 10. It goes to 10 with 10 kids, right? That's 100% of your income.
Right, that's what I was just looking. So if I did 13% times 8 kids.
It's 10 kids, 8 women.
I know, but even with just the 8, it's 104%. Like, how does that work? Are you sure that's right? That you have the table right?
Yeah. So I'm going to go out on a limb. So I was just doing some math here. So in order to have 10 kids with 8 women, he either has to have 3 kids with 1 or 2 kids with 2.
Okay.
Okay.
Or he can have like 4 kids with what? Like, yeah, you don't know what it is. You don't know the mix.
If there's 8 women, they each at least have to have 1.
Okay.
Which leaves 2 kids to spare.
Okay.
So either one person.
I'm following. I got you now.
Okay,
Go.
okay.
Okay.
Welcome to the show. All right. So if it's 2, if 2 moms had 2, I can't do it because it only goes to 7. I don't know what it would be.
There has to be like 7 or more. There has to be like.
Well, I didn't look at that. I'm just looking in the thing. Toolkit.
Oh, the toolkit. Okay.
Only goes to 7.
Okay.
I don't know what the math would be, but
Daniel, do you know? Where's Daniel? We need a lifeline here.
I hear that Amsterdam's a really cool place to live.
I don't know that we've ever had that situation.
I have another fan, David. Thank you, David. I agree with you.
Ignoring that.
I am David.
So, would I be able to support myself? No.
No way. No.
30 seconds.
Yeah.
Yeah, I don't know. That would be very interesting. I guess that, you could request or argue a deviation from the guidelines and say, judge, I can't afford. I don't know how much leniency we would get from a judge, but
I'm not even very sympathetic.
I know.
You think after a couple he learns what causes that? He's taking Strabia's class or something.
Oh my gosh. Yeah, I'm sorry is all I can say to this gentleman.
I'm not.
I mean, it's just, there's nothing we can do. There's nothing a lawyer can do. Like yeah, I don't know. Do you have anything else?
Condoms are cheaper.
I agree. Okay, next question. You ask?
Sure. My husband left. Is he required to pay bills? My husband packed up his clothes and left suddenly. We are not divorced. Although he did file after leaving, is he still required to cover bills like rent and utilities while we are still married, even if he's not living here?
Maybe. So what we would do in this particular case is we'd file a counter petition. We would request temporary spousal support, and then we would request that the court ordered that he be responsible for certain expenses or to give you a certain amount of money each month to help you cover those expenses. But just because, if without a court order, no, but you have the ability to request it.
So I'm probably remembering incorrectly, but I thought I read something at one point that said the husband or the spouse has a continued obligation to support that spouse until both parties have attorneys, and then the obligation ceases.
Well, I know that there's a duty to support your spouse. Like that is a duty that's listed in the code, but I don't remember anything about both parties having an attorney.
Yeah, I thought it was really weird too. I'm gonna look that up.
Okay, look it up. But so even if, let's just say, assuming that that's correct, there's no way to make him do any of that stuff until you get a court order. So you'd have to file a counter petition, request a temporary orders hearing, go to court, explain to the judge why you need his help with rent and utilities. And then from there, the court will make a determination on whether or not you are eligible to receive spousal support. So what I will say is when it comes to spousal support in the state of Texas, it is difficult to get an order that will allow you to get that. A lot of judges just are not big fans of spousal support. The code really kind of incentivizes a limitation on spousal support. But even if you're not married for 10 years or more, everyone is eligible to receive temporary spousal support if there is a need for that spousal support. Okay. And so what we will typically do is we'll do what we call a financial information statement. In this financial information statement, we will say, okay, here's a list of all of my bills, Judge. So my bills each month are $5,000 and I only make $4,000 a month. So I need my husband to give me $1,000 a month for me to be able to pay my bills. Right now, if husband is paying $1,500 a month in child support, then you're probably not going to qualify for spousal support because you have more than enough to pay for all of your expenses, right? But if with child support and with your income you can't cover, then the judge can give you that extra money. But it's not just okay, well, he bounced and I need help and I'm going to get he has to pay my rent. It doesn't work that way. Spousal support is only to cover your minimum reasonable monthly needs each month until such time as you can cover yourself, or if you guys get a divorce, when that happens, depending on the length of marriage, post-divorce spousal maintenance is a possibility. And there's some other factors that the court can consider to give you post-divorce spousal. Cool.
Yeah, so I think, yeah, you got it. But so you can't compel him to do it right then, right? Your remedy is going to be a reimbursement based on his duty to support, right? So you could get spousal support going forward, but you could also potentially request that you be reimbursed, or if the bills weren't paid, that he'd be required to go back and pay the bills that he otherwise had a duty to pay anyway.
Did you find that provision you were saying?
Not yet. Yes. The fiduciary duty terminates in a contested divorce when each spouse is independently represented by counsel. Solares v. Solares, 232 Southwest 3873.
Good job, Floyd. That's impressive. I did not know that.
Yeah, I thought it was weird. When I actually, it's the one sentence on this page I highlighted because I was like, that's weird.
Was that from a lunch and learn? Is that where you read that? And
It was from a lunch and learn, yeah.
Yeah.
And otherwise, the fiduciary duty ends when the marriage is dissolved.
So it makes sense.
Yeah.
Because if you're both represented by counsel, then there should not be a fiduciary duty.
Well, yeah, if you need money, they'll go get it for you, right?
So going back to your argument or your statement of you can maybe go back and do like a retroactive thing. Have you ever done that?
No, not that I can think of. It just popped in my head when you were talking about it.
Yeah, I think that it's something we should try to do moving forward, but I've never done it. Okay, it's our little secret.
It's gonna be used against us.
I know.
Rob you, cover your ears.
Okay, one last question.
Yeah.
Okay. My turn to read or yours? I think it's yours. Okay.
I just read My Husband Left. You answered that question while I was researching.
Okay. Which one do you want?
I don't care. Give me an easy one. I can answer in 30 seconds.
Okay. I am the NCP. I filed for child support modification through OAG. Why am I receiving a citation saying I'm being sued? Long story short, my mother has had custody of my son since 2015, paid child support to her through the OAG. My son moved in with me in 2020, has been with me full time since, and he's only spent 1 weekend with her. I honestly don't know why it took me this long to file, but I just recently filed for a child support review. It was accepted, waiting on a court date. But why have I received a citation saying I'm being sued and to file a written answer? I don't understand. Also, will the judge change the custody order as well during the modification hearing since my son has been with me full time for 3 years?
So to answer your first question, that's because that's what every citation says, and the Attorney General does not represent you. They represent the state of Texas. So you would be a respondent. So when they file the modification that you requested that they file, they have to serve you with a citation that says that you have been sued. So that's why it says you're being sued, and you are required to respond to that, or be subjected to default. Listen to 17 minutes ago, and you'll hear the consequences of that.
Right.
Will the judge change custody during the modification? I don't know. It depends on the fact. I mean, the judge certainly can, right? It's the voluntary relinquishment of 6 months. Judge certainly can, but I don't know all the factors. Right? I mean, you may test hot on a meth test or something, and then the answer is no. But assuming that all's on the up and up, and you're not doing anything wrong, yeah, judge should flip custody at the temporary hearing.
But I think that he is probably going to have to file a his own counter petition, motion to modify, right? To bring that before the court, because it seems as though it's just a child support review where they're just trying to modify his child support. So
yeah, true that.
You'd have to file a counter, and then depending on I was thinking about his child support judgment. If he's had the kiddo and he hasn't been paying child support this entire time, I mean, it's his mom. Maybe she'd be cool and just agree that he doesn't owe any back child support.
I feel like that's not the case, which is why you had to contact the Attorney General to get child support stopped.
So then what happens to all the child support maybe he wasn't paying?
So I've seen it done both ways, but I would go in and request credit for what's it called? Actual support.
Yeah.
But then you have that whole, you can't retroactively modify a child support order, right? But I think judges typically try to be fair. And it's not fair if he's paying child support and mom's living in Hawaii on that money.
But I don't think legally they can. Okay.
Don't tell the judge what he could do legally.
That's right. Who am I to say that? So, yeah, this guy, whoever he is, he definitely needs to hire an attorney to make sure that everything goes smoothly in that hearing, because there's a lot of moving parts. So with that being said, it is 1 o'clock. We got to go. So as we state, beginning, middle, and end of this session, Do not accept this as legal advice. We're attorneys, but we don't know your particular situation. And depending on what is going on with your court order, with your kiddos, with you, it can change our perception of what is going to happen. And so make sure that if you find yourself in this position, that you do hire yourself a really good lawyer, explain your fact pattern to them, and then follow their advice. And with that being said, I hope everyone has a wonderful Friday.
One thing real quick before we go. I just realized we didn't tell them that we were attorneys at the beginning. This is the first time they've actually heard that we are attorneys. So they've been disregarding everything we said.
Well, good. Okay, excellent. Maybe we need to work on that. We got to work on the intro. So, okay, bye.
Toodle.